kinds of discussions that happen. And sometimes people do say things of, here's what my boss is thinking, but don't share it around. I mean, I must have had, so many conversations in the course of my life like that, where someone's saying like that about something. In other words, trying to give you a heads up on something. And that just seems standard Senate staff. So nothing, the direct answer to your question is, for example, looks like Biden's staff's not asking him not to attend the hearing. That wouldn't have raised anything at all for me other than
not even where it came from. On June 5th, 2003, you received an email from a Republican Senate staffer with the subject line, spying. That is not overly subtle. This staffer appears in over 1,000 documents we received together with both you and Mr. Miranda. She says she has a mole for us, and so forth. None of this raised a red flag with you?
It did not, Senator. Again, people have friends across the aisle who they talk to. At least this was my experience back then. Maybe it's changed. And there was a lot of bipartisanship on the committee. There was a lot of bipartisanship among the staffs. There were a lot of friendships and relationships where people would talk to, I've got a friend on Senator Ted Kennedy's staff, or I have a friend on Senator Hatch's staff, or I have a friend on Senator Specter's staff. That kind of the conversation and information sharing was common. So it did not raise the flags.
Judge, I was born at night, but not last night. And if I had something that somebody said, we've stolen this, or this is high, don't tell anybody we have this, I think it'd raise some red flag. Now, we only have a fraction of your record, and I do thank the chairman for opening us up at 3 this morning. But as you know, the president has asserted executive privilege the first time we've had to face this up here on a nominee from either Republicans or Democrats. Of 102,000 pages of material, 102,000 from just your time in the White House. That includes a lot on judicial nominations. Can you confirm for me today that in that 102,000 pages, that there are no emails from Mr. Miranda marked highly confidential or do not share or take no action on this, describing what he has found out the Democrats are thinking?
Senator, I am not involved in the documents process, so I don't know what's in them.
Well, that is convenient. But we don't know what's in them either, because we've never had so much withheld before. We don't know what's in all the documents. They're still being gone through by the archives, because this is being rushed through and we don't get a chance to see them. That's not fair to us, and frankly, Judge, it's not fair to you. You've probably been told you have the votes to be confirmed, so you don't have to care. But I care. I care about the integrity of the Supreme Court. I care about who's on there. I think you should care what's in that, just as we should care what's in it. There are even more documents than I had time to discuss today. I find it impossible to reconcile what you're regularly being told, that your testimony that you received nothing stolen, had no reason to suspect anything was stolen, when, frankly, as we now know, Republican staffer Manny Miranda stole things. And some of the things he stole went directly to you. Let me ask you another one. You testified in 2004 that aside from participating in a moot court argument, you did not work in the nomination of Judge William Pryor. Now, he was a controversial nominee called Roe versus Wade, the worst abomination in the history of constitutional law. He argued that constitutional right to same-sex intimacy would logically extend to activities like necrophilia, bestiality, pedophilia. You said you didn't work on his nomination personally, but you did participate in the prior working group, did you not?
We all were met, just so you know the process. There was something called the White House, I think, Judicial Selection Committee, and Judge Gonzalez, the counsel to the president, chaired that committee. And that started immediately after President Bush came into office in 2001. And so we would meet with memos, and individual members of the staff would be assigned to different.
Did you interview William Pryor?
I don't believe so. It's possible, but I don't believe so. But if I did, it would have been part of the general process where people came in.
I put in the record or Exhibit C, which said you did interview him.
It's possible. We interviewed hundreds of nominees, as I said, Senator, and we met every week for several years to go over nominees. And we worked closely with the home state senators. I had various states for district court. I had Illinois. I had California. I worked on Senator Feinstein, Senator Boxer's staff. Maryland, Senator Sarbanes and Senator Mikulski. But then we would sit in sometimes on interviews of other people who came in, and then we would meet and go over the memos. Then we would meet with the president. We met every week with the president before September 11th. After September 11th, those meetings became less frequent.
You had recommended him internally for the 11th Circuit seat, had you not?
Well, I have no reason that I wouldn't have recommended him, because he was a highly qualified Attorney General of Alabama, and Senator Sessions, of course, knew him well, and he was well respected.
The only reason I asked was that one of the emails that we have up here says, Brett, at your request, I asked Matt to speak with Pryor about his interest. I'm not asking these questions to get you in a bind, Judge. I'm asking them because it is so easy on these hearings to say, I don't remember, and oftentimes that's the case. But you mentioned Mr. Gonzalez. He had difficulty remembering when he came here. He had one hearing where, so that he wouldn't have that problem, I gave him, I think, 35, 45 of the questions ahead of time. On every one of them, he said, I don't remember, I don't recall. And then every question asked, almost every question asked by both Republicans and Democrats, said, I don't recall, I don't remember. Shortly after that, he went to private practice. But I think it is so difficult when that you don't remember the things done by somebody who I think on both sides of the aisle we would agree is one of the most egregious breaches of committee confidentiality when Manny Miranda stole material from here, stole it to send it to you and others at the White House. And you have no recollection of that.
I obviously recall the emails, or have seen the emails, but your larger question was, did that raise a red flag? And I've answered that no.
Well, when you're in the White House, was part of your job to coach President Bush's judicial nominees how to answer Democrats' questions about Roe versus Wade?
Part of our job would have been to prepare nominees more generally, and it was common for senators to ask that question then as it is now. And so I assume that we would have been involved in going through mock sessions I know we were involved in going through mock sessions, which is very standard for Democratic.
Well, you've been going through some mock sessions with at least one Republican senator from this committee and other Republican senators, and I'm not saying that is a gotcha thing. You have every right to do that. You did advise Priscilla Owen exactly how she should respond to that according to one of the emails. And my last question, do you agree that a plastic firearm created with a 3D printer so that we would not have been in the minds of our founding fathers at the 18th century, would you agree that that could be regulated or banned without creating any Second Amendment questions?
I think there might be litigation coming on that, Senator. So, consistent with judicial independence principles, I shouldn't comment on a potential case like that. So, thank you.
I actually written out your answer ahead of time, and I just wrote it so that you did not see what I wrote. Thank you very much, Mr. Chairman. Senator Graham.
Thank you, Mr. Chairman. I'd like to introduce into the record an op-ed from the LA Times editorial board entitled, "Can the Supreme Court Confirmation Process Ever Be Repaired?" Bipartisan letter from 23 of Judge Kavanaugh's classmates at Yale, a letter signed by hundreds of Yale students, alumni, and faculty, a letter from Georgia's Secretary of State Brian Kemp, an op-ed in the Clarion Ledger by Mississippi Governor Phil Bryant. So I'd ask that that be allowed. Just say without objection. That's good. Okay. All right. Thank you, Judge. There are several things I want to go over with you. One, I want to compliment Senator Lay in this regard, that he worked with Senator Grassley to get what had been previously committee confidential released to the public. And so that's the way it works around here. You don't always get what you want, but you try to work with your colleagues, and many times you can succeed. From a public's point of view, it's got to work this way. You just can't do everything you want in a legislative body. There are rules, and it's frustrating to be told no on something you're passionate about. But I'm often asked, people wonder, are these hearings turning into a circus? And I want to defend circuses. Circuses are entertaining, and you can take your children to them. This hearing is neither entertaining nor appropriate for young people. Now, some of my colleagues, who I respect greatly, are trying to make a point. I don't know what that point is. But I do know this: if you want to be president, which I can understand that, it's hard. And what you do will be the example others will follow. Back to the subject matter, the Morrison case. Was that about separation of powers?
That was a separation of powers case.
Okay. It was about a congressional statute and the authority of the executive branch and how they interacted. Is that correct?
That's correct, and a very specific statutory scheme that was unprecedented, had the judiciary involved in appointing counsel.
And apparently, Kagan and Scalia agreed.
Yes.
But Kagan agreed with Scalia's dissent.
She's called it one of the greatest ever written, and she's added it gets better every year.
Well, I don't want to get in the habit of saying listen to Elena Kagan, but I will here. Because she's a fine person. The situation we have before us about Mr. Mueller, that's not a separation of powers issue, is it? Aren't these different facts? That Mr. Mueller was appointed through Department of Justice regulations.
Senator, I don't want to talk specifically about current events, but I will just refer back to what I've written previously about special counsel.
I'm not asking you to how to decide a case. I'm just asking, do you read the paper? Do you watch television? The special counsel statute in question doesn't exist anymore, does it?
The independent counsel statute
independent counsel
does not exist anymore since 1999.
Okay.
The traditional special counsel system I've written about is the ordinary way that outside
But
investigations.
is that an executive branch function?
That is ordinarily appointed by the Attorney General and is
Who's a member of what?